Hello everyone. Please write in the chat box if you can hear me well. I'm so sorry for this inconvenience. We had some technical problems. Can anyone hear me? Yeah, okay. Thank you. Thanks for sharing your time with us. My name is Olga Rudnicka and I'm legal advisor at Eltoma Corporate Services. Today we will discuss the topic Singapore Company Incorporation, Maintenance and Liquidation. Please use our chat box to ask the questions you are interested at. All the answers you will receive after the webinar if we have some time, or I will send you all the answers during the day to your emails. Hope that the webinar will be useful for you. So today we will discuss with you the following questions. So first of all, it's forms of business entities, incorporation procedure, company documents, director and secretary of the company, shareholders and types of shares, know your client procedure or KYC procedure, fill-in requirements for companies, liquidation and strike off of Singaporean companies. So the most relevant documents which are to be taken into consideration when we're talking about the incorporation in Singapore, when we're talking about the maintenance of Singaporean companies are as follows. So first of all, it's Companies Act, specifically Chapter 50, Original Enactment, Act 42 of 1967, and its revised edition of the 31st of October 2006. So first of all, who can incorporate company in Singapore? So of course, Singapore ordinary resident or Singapore fill-in agent. For example, Eltoma Corporate Services is a Singapore fill-in agent, so we can assist clients in incorporation of Singaporean companies. So what is a fill-in agent? So first of all, it's a professional company which is regulated, which work is regulated by ACRA. So these fill-in agents should have a qualified person. This qualified person has a professional number, and this very professional number allows to incorporate and maintain a Singapore company for foreigners. So what is actually ACRA? It's a Singaporean registrar, which if we're talking about this abbreviation, so ACRA stands for Accounting and Corporate Regulatory Authority. It was formed as a statutory board on the 1st of April 2004, following the merger of the RCB and PAB. This institution is responsible for recording of incorporation of new Singapore legal entities and maintaining records of changes in these very entities. So under the legislation, there are various types of business entities which can take place in Singapore. So under Business Registration Act, there are two forms. So first of all, it's sole proprietorships, and second one is partnerships, which the general one. Under Limited Liabilities Partnership Act, there are two options, which are Limited Liabilities Partnership and the Limited Partnerships Act 28, Chapter 50. There can be companies incorporated in Singapore and some branches of foreign companies opened in Singapore. So first of all, there are three main categories, three main types of companies in Singapore: a company limited by shares, a company limited by guarantee, and an unlimited company with or without share capital. So, companies limited by shares are the most common type of companies in Singapore and are usually profit-making businesses. The liability of the members are limited in their Memorandum of Association, and they are limited to the amount unpaid on the shares taken up by them. If the members' shares are fully paid up, the members have no further liabilities to the company and need not contribute to the payment of the company's debts should the company become insolvent. So there are various types of limited liability companies, the private ones and the public ones. If we're talking about the private ones, such companies can be in a form of private exempt companies if satisfy specific criteria. So these privately limited companies is a LLC in which the shares are held by less than 50 persons and are not available to general public. So most privately incorporated businesses in Singapore are registered as private limited companies. A private limited company's name in Singapore usually ends with private limited or PTE Ltd. So some clients, are asking about whether we can remove this PTE Ltd from the name of the company, but no, we cannot, because uh, that's the part of the name, and it stands for private limited. So the shareholders of a private limited company can either be individuals or corporate entities, or maybe both. But then there will be some differences, in the structure and in the liabilities of the shareholders, and the stamp duties paid, some liabilities paid when they shares and transferred from one to another. If we are talking about the public companies, it is such companies are a LLC that may offer its shares to general public. So public limited companies must have at least 50 shareholders and is subject to significantly more stringent rules and regulations since they have the power to raise funds from the public. So usually such companies is listed on a stock exchange. So the main difference is that the private limited liability companies, they have less than 50 shareholders, and if your company have 50 and more shareholders, then it becomes public limited liability company. A company having a share capital may be incorporated as a private company, where the constitution of the company restricts the right to transfer the shares of the company and limits the number of shareholders to 50. So that's what we were talking about previously during the previous slides. So if we are talking about the exempt private company, it is a subcategory within the class of private companies, which enjoys certain privileges under the Company Act. So they are subject to the following restrictions. First of all, the shares of these exempt private company must not be owned directly or indirectly by the corporation, and this company must not have more than 20 members. And what is more, we can add is what more can be added is that these exempt private companies, they cannot have corporate shareholders. So they can have only the shareholders of such companies can only be people, physical entities, not corporate ones. So, privileges and benefits of being an exempt private company include the exemptions from submission of financial statements with its annual returns. So, the only thing which is filed is directed declaration of solvency. That's it. The second exemption is as follows. So, restrictions on loans to directors and persons connected to directors under Section 162 and 163 of the Act. When it comes to an annual statutory audit, if it's annual revenue, if the annual revenue of the company is 10 million Singaporean dollars or less, then you are exempt. You may enjoy this exemption from the annual statutory audit. So when we're talking about the tax exemption, I'm so sorry. If we're talking about the tax exemption scheme for new startups and the qualifying conditions for first 3 years, so that's another exemption you may enjoy when you're having an exempt private company. Going further, let's discuss dormant companies. Actually, what the dormant company is and which privileges you may enjoy having it. So, Section 205B acknowledges the presence of dormant companies in Singapore. The section provides that a company shall be exempt from audit requirements if it has been dormant from the time of incorporation or since the end of the previous financial year. So the period within which the company is considered dormant is a period in which no accounting transaction occurs. When it comes to transactions, some of them shall be disregarded for considering a company dormant or not. So, first of all, I'm so sorry for this interruption. The following transactions shall be disregarded for considering a company dormant or not. So, first of all, the taking of shares in the company by a subscriber, then the appointment of a secretary under the Section 171, and the appointment of an auditor under Section 205. Of course, we cannot exclude this maintenance of the registered office and the secretary services. We may not disregard the keeping of registers and books, and the payment of any fee or any fine penalty paid to the register. We just may not. We may disregard only the some filings, but not the ones listed on this very slide. The matters applied by the end of the financial year to the dormant company are as follows. So first of all, it is the copies of financial statements or consolidated accounts need which are not to be audited. Next, it's the annual return of the company to be lodged with registrar, which shall be accompanied by a statement of directors confirming the dormant status. According to the Singapore Companies Act, any person foreign or local above the age of 18 can register a Singapore company. But the foreigners wishing to open a Singapore company must take into consideration several points. First of all, they must engage a professional firm to register a Singapore company, because you need a secretary there, you need a professional filing agent in Singapore to register it. And one should bear in mind that Singapore law does not allow foreign individuals or entities to self-register a company. And one more detail, one should keep in mind that only Singaporean resident can be, if you want to register a Singaporean company, then you must have at least one director who is a resident of Singapore. So actually, there is no requirement for foreigners to obtain any special Singapore visa if they merely want to incorporate a private limited company, but have no plans to relocate to Singapore. If foreigners plan to relocate to Singapore to operate there, I'm so sorry. If foreigners plan to relocate to Singapore to operate the company, they are required to obtain some passes to work there. So first of all, there are two options. You may obtain an employment pass or an entrepreneurial pass. So once the client obtains the work permit, they can act as a local resident director of their company. So there will be no need of the nominee director in place and in charge of your company. So what are the steps of incorporation? So first, it's company name approval. Of course, you may send to your agent some set of names which you want, which you would like to use, for example, for your future company, and then the agent will get the approval from the registrar. Maybe the name you want to use is not available at the moment. So first of all, first step is to get this very approval. Then the registration process starts. But if we're talking about the company registration, so first, prior to this very step, the company registration step, you should pass this QAC procedure within the registered agent. So first of all, you should send all the required documents to the agent. So we will mainly touch all these within the when we will discuss the QAC procedure. But in just briefly, to give you some impression of this, so you should the client should send if the beneficial owner is it's always a physical entity, and one should send to the registered agent 2 documents which will confirm the identity of this very person. So there may be 2 passports, for example, the internal and the travel ones, or there may be a driving license, or maybe ID card of some other countries. Then you should send to the registered agent a signed CV or a resume, and the proof of address, which should be not older than 3 months. So in general, it is a utility bill. So when then we're going, if everything is okay with the client, we may start this very company registration procedure. So both steps, I mean, the company name approval and company registration steps can be accomplished on the same day, assuming there are no delays caused by company registrar. Company registration procedure in Singapore is fully computerized by the Singapore Registrar of Companies. So the Singapore incorporation process is very quick and it's very efficient without any bureaucratic red tape involved. So under normal circumstances, the company can be incorporated within 3 days. Not like 1-2 days. Of course, we can incorporate the company within 1 or 2 days. There is no problem in it, but it all depends um, on the documents provided by the client. So if the client provides all the relevant, all the needed documents on time, there will be no delay. If all the documents will be signed by the client on the same very day, there will be no problem to register the company within this 1 or 2 days. But if there are some delays on this, then we'll have some delays as well in the process of company registration. So, of course, a company shall, as from the date of its incorporation, have the registered office within the Singapore. So the registered office must be opened and accessible to the public during ordinary business hours every day except weekends and holidays. So the place of the business in common practice is not the same as registered office address, but the secretary must be presented at the registered office and the registers and statutory books must be kept there. So the secretary must keep all the books, all the papers, all the registers on the company, and there should be no obstacles to for um, for um, for institutions to check everything they want. The Memorandum of Association in the company's constitution and sets out the essential details of the company's existence and must contain the follows. So first of all, the name of the company. So if the company is limited by shares and the effect of it, that the liability of members is limited. If the company is limited by guarantee, that the liability of members is limited and the effect of this in share capital contribution. If the company is unlimited, the liability of members is unlimited either. The full names, addresses, and the occupations of subscribers should be included. This very information should be included in Memorandum of Association. Actually, since last year, there was some amendments have took place. So nowadays there is no memorandum and articles of association. There is only constitution, which covers the provisions which have been previously included in the memorandum and articles of association. So the current main document of the company is called constitution. So the subscribers are desirous of this very document should include that the subscribers are desirous of being formed into a company in pursuance of the memorandum, and that they agree to take up the number of shares set out opposite their respective names. From the 1st of April 2004, the requirements to set out the objects of the company in the memorandum has been removed. However, the company may still choose to include the objects in its constitution. So other clauses governing the issues such as restrictions on share transfer and limitation on the number of members may be included as well. In addition, it is usual to state that the registered office is situated in Singapore. So as well, it should be included in the constitution of the company. So if the person signing on behalf of a corporate subscriber is not a director of the subscriber, a POA or some director's resolution or letter of authority must be lodged with the ACRA. So again, dealing with the constitution, the constitution of the company sets out the rules for the management of the company's internal affairs. Please don't pay attention that it is written down that this article of association it is called also constitution. So I'm so sorry for this kind of mistake. So the Company Act requires the constitution of a company to be printed, divided into numbered paragraphs, and signed by each subscriber in the presence of at least two or of at least one witness who must attest the signature and at his address and occupation. Within fact, from the 31st of March 2017, companies, foreign companies, and LLPs, unless exempted, are required to maintain beneficial ownership information in the form of a register of registrable controllers and to make the information available to public agencies upon request. The aims is to make the ownership and control of corporate entities more transparent and reduce opportunities for the misuse of corporate entities for illicit purposes. So the key points about the register of registrable controllers are as follows. So first of all, the registers of registrable controllers is to be maintained at prescribed places. So the company's LLP's registered office or the registered office of the registered filling agent. The register can be maintained in paper or electronic format. The registers of registrable controllers will be kept only by the corporate entity and will not be made available to the public. Companies and LLPs must give the register and ACRA officers, as well as public agencies administering and enforcing any written law, access to their registers of registrable controllers upon request. So it is interrelated with these requirements are interrelated with the ones we have discussed with you previously. I mean that any day ACRA or any other institution which have the relevant competency, of course, should have access to the registered office like on a daily basis. So the information therein can only be used by public agencies for the purpose of administering or enforcing the laws under their purview. For example, when we're talking about the investigation of money laundering offenses. Companies and LLPs will have to declare with the ACRA the location of the company's register of registrable controllers when filing the company's annual returns or annual declarations. Companies and LLPs can discharge their duties by sending notices to the relevant parties and recording their particulars, as well as sending further notices to any other parties that have been revealed as potential controllers. Notices can be sent and replies may be received in electronic or hard copy format. The company or LLP is not liable, should be recipients of these notices fail to respond or provide inaccurate responses. A controller is required to provide an update and update information to the company. So when we are talking about the registers, if we are talking about the members of the company, if we're talking about the shareholders of the company, Singapore private limited company can have a minimum of 1 and maximum of 50 shareholders. A director and shareholder can be the same or a different person. The shareholder can be a person or another legal entity, such as another company or trust. 100% of local or foreign shareholding is actually allowed. New shares can be issued of existing shares, can be transferred to another person anytime after the Singapore company has gone through the incorporation process. But when you transfer shares, for example, to a corporate entity, some stamp duty should be paid. So the stamp duty depends on the share capital and the amount of shares issued by the company. So when we are talking about the share capital, so I say that you're asking about the minimum amount of this share capital. So there is no no requirement for this, but we would recommend to have at least 5,000 Singaporean dollars, because if you are going to open a bank account in Singapore, it's better to have this minimum, because it is mostly required by banks. Not required, but it's like silent rule, some kind of it. Though the registers, if we are talking about the beneficial owners, no one will see who is the real beneficial owner of the company. But if we're talking about the director and the shareholder, it is filed within the institution, so this information can be obtained actually. Pluses of the dormant companies. It's it's very tricky question, I would say, because it's difficult to talk about the benefits of these statutes. Just that there is no need to pay. The pluses of dormant company. You don't. You are not in need of filing audit financial statements. You still should have this. Should prepare financial statements, but there is no need of audit to be filed, and there is no need to pay taxes. And that's it, I guess. But if we're talking about the benefits, just that you have this company if you need this, and so the dormant company means that you have no activities within this. This company has no activities during the year. So maybe you don't have activities during this year, but you'll have activities during next year, for example. So it's hard to talk about the benefits. It's not about the benefits. It's about your goals mostly. Talking about the directors. It's who is the director? It's the person who occupies the position of a director uh, in the company and who actually manage a company. But as I have told you previously, there is a requirement of minimum one resident director. So a resident is defined as a Singapore citizen, a Singaporean permanent, a Singaporean permanent resident, or a person who has been issued an enter pass, employment pass, or a dependent pass is mandatory. So actually having this resident director is mandatory, but if you as a client has obtained this employment pass, enter pass, then there is no need to hire a nominee director um, to your company. So there is no limit on the number of additional local or foreign directors a Singapore company can appoint. Directors must be at least 18 years of age and must not be bankrupt or convicted for any malpractice in the past. First directors usually retire from the office at the first annual general meeting of the company and are eligible for re-election. I'm sorry, I see your question about the company sales. Actually, for example, if you're imagine the situation if you have some contract to be signed with another company, and some counter agents they want to see your seal on the paper. So the same situation with the bank. When you actually when you file some forms, um, there is a lack of need of the seal. It's mostly the question of having a director's signature on it. But most of the contracts signed with the counterparts, with the suppliers or some partners, whatever, or whoever, will still need this seal on it. So I'm not sure about your question. Maybe you can specify some particular situation so that we can discuss it. Okay, going further with the first directors and appointment of the directors. So subsequent appointments of directors are done by uh, filling up a casual vacancy or as an addition to existing directors. A director of a company shall not resign or vacate his office unless there is remaining in the company at least one director who is ordinarily resident in Singapore, and any purported resignation or vacation of office in breach of this subsection shall be deemed to be invalid. Okay, actually, referring to a question about the seals of the company, for example, if you have a nominee director and you are not appointed as a second director in this very company, so to manage the company, to make some decisions regarding this company, or at least to to manage the corporate bank account, you will have to have this power of attorney issued by the company, and you should on this very POA, the company stamp is required. Actually, the company's stamp and the signature of the director. So most of the banks will regard, for example, this POA um, as a true one, as a working one, if you have both the signature and the stamp. Because if you know, in Singapore, the apostille is not practiced, so there may be some difficulties with the legalization, because it's pretty pretty expensive, and it should be first notarized, then legalized within Academy of Law, within Ministry of Foreign Affairs, and then should be legalized in the consulate of the country in which this very document is required. For example, if we're talking about the power of attorney, if you require this power of attorney, for example, in Russia, then you'll have to notarize this power of attorney. Then you should go to Academy of Law to legalize it there, then to the Ministry of Foreign Affairs, and finally get this final legalization in the Russian Federation consulate. And only after this POA will be workable within the Russian Federation territory. But sometimes, the the banks, even abroad, not within the Singapore, they require the power of attorney only signed and stamped, and that's it. That's why I guess the seal is actually required for these companies. So I hope that I managed to clarify the situation somehow. So going back to the directors of the companies and the duties of the directors. So what are they? So first of all, directors execute fiduciary duties, duties of care and skills, statutory duties, so which are stated within the constitution of the company. Then the directors, observing the restrictions and limitations or prohibitions of a company, they comply with various laws, statutory and voting requirements. They are in charge of preparing audit accounts, filling with IRAS and ACRA, and keeping proper accounting records, and etc. So when we are going to liabilities of directors, there are two types of liabilities: criminal and civil liabilities. So any breach of any statutory obligations may result in criminal or civil liability. Criminal liability may be a fine or imprisonment, even imprisonment, or both. So directors bear responsibility for debts of the company. A director is generally not liable to third parties for the debts of the company, but actually, as the director bears some serious, really serious responsibilities, and there may be some real negative consequences for the director if something is not filed, if some penalties occurred, or some debts of the company, or whatever. The registered agent usually take from the client these director's deposit in order to cover all the expenses in a situation if the client, for example, decides to how to say if the contact with the client, for example, is lost, or where the client just say, I don't need this company anymore, and just is not going to communicate further. And there are still some liabilities of the companies, or some financial statements to be prepared, and so what, or maybe some taxes to be paid. So the director's deposit is actually required. So there are certain exceptions from the director's liabilities. First of all, contracts entered into prior of incorporation, non-use of company name on bills of exchange, or some similar, fraudulent trading, intention to defraud, and when dividends are not paid out of profit. So turning to the company secretary, I'm sorry for this noise. We will, sorry, just 10 seconds. So as per section 171 of the Singapore Company Companies Act, every company must appoint a qualified company secretary within 6 months of its incorporation. It has to be noted that in case of a sole director shareholder, the same person cannot act as the company secretary. The company secretary must be a natural person who is ordinarily resident in Singapore. Provided that the office of secretary shall not be left vacant for more than 6 months at any one time. So, going further to the discussion of shares of the company, the Companies Act 2005 abolished the concept of nominal value and authorized capital. With the effect from 30th January 2006, all shares shall have no nominal value. The concept of share premium and discount had ceased to exist. So the market value of a share is the actual value. In the private company market, value is usually calculated on the basis of net tangible assets. So going further to the capital structure. So following the abolition of concept of nominal value and authorized capital shares may be issued for any amount and with no limit. Minimum paid up capital for registration of a Singapore company is $1 Singaporean. So actually no minimum share capital is established and is required. No, one Singaporean is, so paid up capital can be increased anytime after the incorporation of the company. So what are the general classes of shares? First of all, there are ordinary shares, preference shares, cumulative and non-cumulative preference shares, redeemable preference shares, convertible preference shares, employees shares. So the very procedure I was talking about previously when we were discussing the steps of incorporation. So this very know your client procedure. This procedure is established to obtain essential information on a client, its business and sources of wealth. For example, CV, bank reference letter, documents which prove identity of a person, and the place where the person is currently living. So presentation of a client as an individual through a passport. A passport is checked by World Check or World Compliance. So if any suspicious activity or activities were held by the client previously, then I guess there will be some difficulties in establishing the company and registering the company. Um, Residence address proof ascertained through a less than 3 months old utility bill. It's better to have this utility bill, but in some cases, when it's difficult to obtain this utility bill or some registration, if we're talking about Russia, then they stamp in the internal passport. If we're again talking about about Russia or maybe Belarus or Ukraine, this stamp in the passport can be regarded as well. Okay, referring to the seal as well. Actually, when you asked a registered agent to assist you in the process of company company registration, the whole the agent has its established price, and this very price on the incorporation of the company includes this very price on the seal. I'm not sure. Actually, if you apply to for a bank account opening, and you have no seal, that's kind of strange because um, actually some banks, I guess even most of the banks, require the seal on the bank forms. So I think it will be normal from the bank side to reject such application, to just to avoid some um, fraudulent activities maybe from this very person side, because the bank should be sure that you have all rights to proceed with bank account opening on behalf of the company. So actually, again, when we're talking about the bank account opening, it all depends on the bank you choose, because each bank has its own internal rules, internal procedures, and maybe in one bank, bank officer will tell you, okay, it's okay to have only signature on the application and that's it. But the other one will tell you, oh, I'm sorry, but it's kind of suspicious that you do not have a seal. So anyway, it's better to have a seal, because even if we're not talking about the bank account opening, believe me, there will be situations when you will need this seal, especially when we are talking about the signing of some contracts with the counterparts. So going back to know your client's procedure, there are different categories of the clients: high risk, medium risk, and low risk clients. So the concept of a high risk client includes the following points. So when a company is banned without a physical presence of a client, or includes or involves a politically exposed persons, that is definitely high category risk. High risk category. So sorry. So it is statutorily required to get update on a client details at least once a year for high risk clients. So deployed, if we're talking about the nominee services, so of course it is deployed to protect identity of a client, because if you have a nominee director, if you have a nominee shareholder, it's difficult to get who is the real beneficial owner, who stands behind the company. So there are two types of nominee services provided, so nominee shareholder and nominee director. So there is no legal concept of a nominee director. A director is always a director, and he is always responsible for the company affairs, for the company activity. So that's why that's really that's really important to have a good lawyer with you, to have a good registered agent, the qualified one, which can prepare the relevant documents to to secure both the nominee director on one side and the client on another side from the fraudulent activities from both sides. So there is a legal concept of a nominee shareholder, and relationships between a nominee shareholder and the client is regulated through a deed of trust. So in this very document, a deed of trust, there are provisions which reflect that the nominee shareholder bears shares in the third party interest. So he has no interest actually in these shares, and holds and keeps them only in the interest of the third party. But if we're talking about, for example, that's about the Singapore, but if we're talking about the Arab Emirates, just to take more about the picture about this very case. For example, there is no legal concept of a nominee shareholder in the Arab Emirates, because actually, for example, in Singapore, if you have a nominee shareholder and this very shareholder did something with your shares, you may go to the court and say that, oh, come on, this person holds shares on my behalf, so that's my shares, not his one. So and the court will say, okay, yes, and will oblige this nominee shareholder to make some proper actions. But if we're talking about the Arab Emirates, then there is no legal concept of a nominee shareholder, and if a nominee shareholder did something wrong, so it's the local shareholder, for example, he did something wrong with your interests within the company, and you are going to a court saying that this very person is not a real beneficial owner of the company, and I'm a real shareholder, and he keeps the shares on my behalf. I would say it will be really difficult to to pursue the court that you are a real founder, you're a real beneficial owner of the company, and you're a real actually shareholder in this company. So again, talking about the nominee services, it is impossible to completely eliminate risk related to nominee services. So, but this very risk can be mitigated by careful selection of a service provider and properly prepared nominee service legal documents, or by appropriate company structure. So that's very points I was talking about a slide before. So the following legal documents are prepared usually. So it's trust deed, indemnity agreement, or indemnity letter, instrument of transfer, and a resignation of a director with an open date. And of course, an appointment letter with an open date as well. And some instrument of transfer of shares with an open date. If we are talking about annual requirements for maintaining the Singaporean company, all locally incorporated companies are required to hold their annual general meeting and file their annual returns under the Company Act. So at the AGM, annual general meeting, directors shall present a true and fair view of the company's accounts, consolidated accounts to the shareholders. The appointed officer of the company, director and secretary, they shall file the annual return via BIS file. So as I have previously told you, there is most of the procedures are computerized in Singapore, so it's quite easy to maintain the company, to face less of bureaucracy than in many other companies. No, I'm sorry, not companies, but countries. So based on the company's financial activities during the accounting year, the annual financial accounts, consolidated accounts, must be prepared in accordance with the financial reporting standards of Singapore. Audit of financial accounts are required. Once the financial accounts are ready, a company may be required to have its accounts audited if the company falls under one of the following points. So the entity is a Singapore company with corporate shareholding, or entity is a Singapore company with annual revenue exceeding 10 million Singaporean dollars. So if we're going back to the annual general meeting, once each calendar year, this very meeting should be held by the Singaporean company. Some general rules apply to AGMs. So first of all, the first AGM must be held within 18 months of its incorporation. So between the following AGMs, no more than 15 months may occur. Accounts presented at the AGM shall be made up to a date not more than 6 months before the AGM. And when we're talking about private companies, they are allowed to dispense with AGMs if at the general meeting of the company, a resolution to that effect is passed by all members with voting rights. So again, if we are talking about the filing of the filing of annual return, each company must lodge an annual return with ACRA within 1 month of its AGM. So particulars of the company offices, registered address, auditors, and audited, unaudited financial statement must be included in the annual return. Another obligatory document which is to be filed within the company or each year is an estimated chargeable income, or ECI. Singapore companies are required to declare the revenue amount and estimated chargeable income by filing an ECI form with Inland Revenue Authority of Singapore, or IRAS. Within this very document should be filed within 3 months of the financial year end for the company. So even if the company estimates its chargeable income as zero, it still has to file a nil estimated chargeable income form. So one should not forget about the annual tax return. So each Singapore company must file its annual annual tax return with IRAS by 30th of November of each year. Singapore adopts the preceding year basis for taxation. The profits for the financial year ending in the preceding year will form the basis for filing the tax return in the current year. So one should note the following points. So first of all, the directors of the company are responsible and accountable for complying with the annual filing requirements. And the second one, failure to comply with the statutory compliance requirements is an offence and may result in fines or prosecution. I'm sorry. So if we're talking about the non-compliance under the sections of 400 till from 400 till 409A clauses of the Company Act, some of the further offences are included in these sections. So first of all, false and misleading statements, false statements or reports, obtaining payments, obtaining payment of monies, and etc. To company by false promise of officer or agent of company, and some frauds by officers. Because, of course, these offences are punished by fines or imprisonment or maybe both, so it's better to avoid these such actions. So going further to the topic of liquidation and strike off of the Singaporean companies, we should consider the following options. So first of all, a company may be closed voluntarily by its owners or by an order of the court. If some special or some sudden circumstances occur. So under company law, it is the duty of directors to wind up an insolvent company. Companies can be liquidated either by striking off or winding up. So winding up and striking off, both of these procedures result in a company ceasing to exist. However, there are these very procedures are they're very common. I'm sorry, an opposite one. They are very different processes and should not be confused with each other. So if we're talking about this strike off, the company may apply to ACRA to strike its name off the register pursuant to the Section 344 of the Companies Act. So ACRA may approve the application if it has reasonable cause to believe that the company is able to satisfy the criteria for striking off, or may not approve it. So what are the requirements which is relevant to follow if you want to have this approval? So first of all, the company must have ceased trading. The company must not be involved in any court proceedings, whether inside or outside Singapore. The company must have no assets and liabilities at the time of making the application. And finally, the company must not have any outstanding penalties or offers of composition owing to the registry. In addition, the company must not have any outstanding tax liabilities with Inland Revenue Authority of Singapore. The company must not be indebted to other government departments. And the officers of this very company, both the directors and the secretary of the company, must not have any outstanding summonses from ACRA against any of these very persons in charge of the company. In addition, the particulars of the directors must be the same as in the records of ACRA. So all the shareholders must consent to the striking off, and the company must obtain a letter of consent from each individual shareholder. So, for example, is ACRA completely satisfied and the company fully meets the criteria for striking off? A striking off notice will be gazetted for objections by third parties and will be sent to the company at its registered office address, and to its officers, director and company secretary, at their residential address, and lastly to Singapore tax authorities. So after a period of 4 months, a final notification will be made and gazetted stating that the company has been struck off the register. Of course, during all this period, no objections should be made to the company registrar. So, if any objection, then you won't get this approval, and you should start the process all over again. So, turning to the winding up of a company. So, actually, what the voluntary winding up process is. First of all, the members of the company sign this declaration of solvency. They pass special resolution, and finally winding up of the company affairs. So besides, there should be creditors voluntary winding up as well. So the two types of winding up, one's voluntary, which I was talking about previously, and the other one is a compulsory one. So what the effects of voluntary winding up are? So first of all, with effect from the date of passing of the special resolution, the company must cease to carry on its business except insofar as it's required for the beneficial winding up in the opinion of the liquidator. The director's powers will cease, obviously, except where the shareholders, with the consent of the liquidator, have resolved that the directors should continue to have such powers. Any transfer of shares is void unless made to or sanctioned by the liquidator, and the statutes of the members cannot be altered. So within this point, we should take into consideration some notification requirements which should be followed. So company must notify the following bodies as part of closing down its businesses. So first of all, the company should proceed with the notification of accounting and corporate regulatory authority. Then Central Provident Fund Board, Inland Revenue Authority of Singapore, and relevant licensing authorities. So it's better not to have disapproval from these institutions. A company may be wound up under an order of the court as well, when we're talking about the compulsory winding up of the company. So the company may be wound up under certain circumstances. For example, if the company is unable to pay its debts, or when the court is of the opinion that it's otherwise just and equitable that the company is being liquidated. So that's the end of our webinar. In this regard, I would like to add that due to the ever-increasing importance of CFC regulations for business and related purposes, we have identified how we can help, and we have expanded our services portfolio into property in Cyprus. So we have a number of unique properties on the market in Cyprus for investment opportunities. Should you wish to find out more about any of the properties, unfortunately, I haven't added it to the presentation, but if you are interested, please, you may enter your email address in the chat box on the screen, or visit our website www.eltomaproperty.com. So if you are interested in some of our services, Eltoma Corporate Services or service offers the following services you may find out on your screens. So which are registration and maintenance of the companies in more than 35 jurisdictions, the creation and restructuring of the international holding structures, immigration services, accounting, audit, and preparation of the financial reporting, international tax planning, opening corporate bank accounts, legal services, assistance in receiving licenses and registration of the trademarks, as you may notice, holding some seminars and webinars. So these are our websites. Please don't hesitate to contact us via our emails, or maybe just calling us. So thank you for your time. Thank you, and hope to see you on the next webinar. Thank you, and have a good day ahead. Bye-bye.